Hi, my name's Scott Gordon. We're going to talk about intellectual property today.
And I'm Jeff Hall, and I just started a business. Oh, am I supposed to keep on saying? I'm Jeff Hall, and I had just started a business where I am producing podcasts and doing other types of video work. And I have a lot of questions about law, the intellectual property stuff,
Okay.
especially. And so I'm glad to be here to learn from you,
Okay, great.
Obi-Wan.
Well, fortunately, I'm an intellectual property attorney, so I can help you with that.
What a
stuff.
coincidence,
Right?
Yeah. Okay. Cool.
Yeah, awesome. So, what are some of your questions? What are you doing? Tell me about your business and what you're doing and the types of things that you're going to be involved in.
Well, a lot of it is, from my understanding, intellectual property.
Okay.
So it's well, I don't. You know what? I don't even know.
What are you doing in your business?
So the business is finding people that are passionate about something,
Okay.
and then helping them turn that passion into a business, and using podcasts as a way for marketing and also for getting, really lead acquisition, like finding people that like the product.
Okay.
Because of an interesting podcast. So the idea is to create these podcasts where experts can sell their ideas or their products or their brand or whatever it is, and then eventually people are going to want to buy it.
Okay. All right, cool. So we're going to talk about a couple of different types of property that you'll have in your company, and then I'll take you through all the intellectual property aspects of it. So there's two main types of property: tangible property and intangible property. Okay, tangible property is like the microphones, the tables, the cameras, the computers, all the stuff that you use that you can physically touch. Right. Okay. The intangible property is things like intellectual property and goodwill, which is your relationship with your customers and their loyalty to your company, and also proprietary information like customer lists, marketing plans, those sorts of things. Okay. And the intellectual property breaks down into a few main areas. You've got copyrights, trademarks, patents, trade secrets, and then a few other kind of fringe aspects of intellectual property like right of likeness, which is your right to have control of the images of you, and those sorts of things. So we'll talk about some of those things today in our conversation. So are you going to produce any products for Wisecast?
Yes.
Okay. What are the products?
Videos. So pretty much video and audio. So
Okay.
those are the two types of the way you can deliver
Okay.
the format of a podcast.
When you produce the video, are you going to have your logo or something about your company as the credits? Or
Yeah,
something
we're
like
going to
that?
have our logo with our contact information.
Okay.
Eventually, we'll probably start creating our own little commercials to give a little bit more about what we do. So promoting ourselves through our clients.
Okay. So in general, products are a culmination of a variety of types of resources.
Yeah.
You'll have, in your case with the videos, you're going to have creative works, and then you're also going to have brands. Okay.
Yeah.
So Wisecast, your company's name, is a brand. And then you might have, so one of the podcasts is Dive In with Amy, right? So
Yes.
that name, Dive In with Amy, is also a brand that you're going to start developing. And eventually, when you have enough content, you'll be able to take advantage of that brand in a commercial way, right? Through advertising or through products offered. I think like mugs and T-shirts and hats and all those sorts of things can take advantage of that brand. Let's use that for an example. Let's say you have a creative cup. Okay, it's a interesting new design of a cup. Has a funky handle, or it's insulated in just the right way. Well, okay, it's an insulated cup. Have you seen those metal tumblers that are insulated? Okay, so let's say you have a unique shape to your tumbler, and it's going to have Dive In with Amy or Wisecast on the face of it. Okay. And also it's going to have some special way of keeping the drinks really cold for like a week. Ice for a week.
Jeez,
right?
Sign me up.
Super new. So in that case, you're going to have a product that's tangible, and it's going to have a brand because it's going to have Wisecast on it, or Dive In with Amy. It's going to have a design because it's going to have a unique shape. And then it's also going to have a unique function, a new way of insulating. Okay. So in that case, that product is going to be a combination or culmination of brands, designs, and functions, or a new technology.
So I can see there's going to be copyright. Wait, no. And that.
So in the videos, there's copyright for the creative work.
Okay.
And trademark.
So copyright means that you can't just go take what we produce and then use it for your benefit.
Right. Yeah.
Okay.
So copyright and trademarks because there's a brand associated.
Okay.
Now the new cup, that would have trademark because it's a brand, and design patent because it's a design, and a utility patent because it's a new technology. So different types of patents. Okay, and we'll get into some of those. Yeah. So
I can see why an engineer would need to know about this stuff.
Yeah, the idea is that a product is a culmination of multiple types of intellectual property, and so it can be covered by multiple types of intellectual property devices. So copyright covers literary works, musical works.
The lyrics and the music?
Your lyrics and the music,
okay.
Yeah.
Because I guess they are both a written language.
Mm-hmm.
Okay.
Artistic works, so like drawings, paintings, videos.
So I have a question for you.
Okay.
There's these animals that are painting, like elephants. Have you heard about this?
Mm-hmm.
Can they copyright that? Because it's the elephant created it, or is it the person that's taking these poor elephants and making them do these tricks? It's deplorable.
Well,
I don't know. Are they unhappy? I don't think they're unhappy. Maybe they are. I don't know.
That's a debatable question too. That's a really good question. So I think the copyright laws require the person it requires a person to produce it. And that can be either a physical person like me or you, or it can be a constructive person, which is like a company.
Yeah.
Okay. So a company, by virtue of hiring employees to create works, will then own the works. And it's not a natural person, but it's a constructive person.
Sure. Yeah, I mean, that happened when I was teaching. I had to go through all sorts of... When I came up with a book I wanted to write,
mm-hmm.
This textbook we wrote, we had to go get permission from our district because we didn't want them to own the book.
Yeah.
So that's... But the thing is people need to know this. If you're working at a company and you have these great ideas, shut your mouth at work.
That's true.
Don't ever bring your own personal laptop or anything. Don't even talk about it at work, because if you're talking about it at work now, well, you developed it on our watch.
Yeah, and it can become company property.
Yeah.
Mm-hmm.
So protect yourselves.
And in fact, depending on the terms of your contract, your employment contract, anything you do related to your work, even if it's done wholly outside of work, may still be company property.
Yeah.
Just because it's related in subject matter to your work.
Yeah. So
that's something to look at.
But no, if you're an engineer or someone that's going into like producing, understand that the company you're working for might own you, and you might want to look at your agreement.
Yeah, that's right.
And I know
we'll get into.
I got an attorney that you could talk to if you needed help.
Yeah.
My dad, of course.
We'll actually get into some of that stuff too, the agreements and all of that. But copyrights, the other things that are covered are poetry, novels, movies, songs, computer software is covered by copyright. The code, the actual code, how it's written, the source code is all covered by copyright, and architecture. And so I had this video, and I want to watch the video real quick.
Is it on YouTube?
No, it's not. So what we're going to do is we're going to go ahead and cut to the video right now. On today's copyright example, I'd like to go to a website called EarSketch. And EarSketch is a project put together by Georgia Tech that allows students learning code to create music with Python code. And if we come here to the EarSketch website, we can look at a competition of songs that were put together by students, and in this person, Robert Marzek, won that competition in this case. We can click here on his link and it will open up a project, and in this project is some compilable code that he's used to create an audio player that will play his music that he's produced using the code. So you can see in the code here, he's defined a couple of functions. Here, the first function, opening section, second function, section A, third function, section B, and he's got sounds that he has selected from a library of audio sounds, and he goes ahead and creates that creates the song using this while loop to create that song measure by measure. So we can compile this code by clicking run, and it'll take just a second here, and it will load the audio player. Once that audio player loads, we'll be able to listen to the music that this code creates. So we've got a few things here. Oh, and this will give us an option to select a volume level. We're going to go ahead and just select the volume to 0, and they'll ask us for confirmation about that, and we'll say okay to that. That's kind of a cool function here in his code. And here's the song. We'll listen to that for a second. We can go ahead and listen by pressing the play button up in this corner. Okay, so you've heard a song that was completely generated by software code, and this is using Python language. So I'd like to take a minute and talk about this song and any other copyrights that you see associated with this song. So let's go ahead and do that now. Okay, what copyrights do you see related to that video about the song?
Well, according to your definition before, you said you can copyright songs, you can copyright software, code, you can copyright, so those two.
Those two, yep.
Or some of the other copyright stuff, not in the video, but just copyright. So see if I can see if I can find it. Okay. Don't tell me the answer, just help me remember what some other stuff you can copyright.
Well, I'll give you all the answers then.
Well, okay, then if you can't get around it, then I can't get around it. Because I got two. The song
and the code.
Okay.
And then there's also the website.
Oh, but that's
a
their
website.
Person.
Yeah.
I didn't. But is that trademarked or is that copyrighted?
Nope, copyright.
Because the content on the website.
The look of the website is copyrighted.
The logo. That's something that's trademark.
Yeah.
Okay. So I saw a trademark because they had their logo.
Yeah. Mm-hmm.
But everything, all the content,
the display of the website, that's all copyrighted.
Okay.
And so that would be copyrighted by Georgia Tech.
Georgia Tech, the university.
The university.
Oh, they're the one that put on the competition?
Mm-hmm.
Okay.
So the kid who won the contest, he would have copyright in the song and in the code that he wrote.
Yeah.
And then Georgia Tech would have copyright in the website.
Do they share the copyright with the material? Did you look at the contract?
No. So it may be that because of some contract, the person who entered the contest assigns his copyright rights to the university in the song and the code.
Yeah.
That's probable, actually.
Well, like Elise, when she does, my wife's a photographer.
Mm-hmm.
So when she takes the picture, they both own the copyright.
Oh, really?
So she owns it and they own it. So she can use it for her.
Is that by agreement?
Yeah. Oh, yeah. She puts that in agreement saying, look, I can use your images for my website, for my promotion.
Mm-hmm.
These are my images, and I'm letting you have half of the ownership, essentially.
Yeah.
some photographers, I guess, will just keep the whole rights to them. Like, these are mine, and you can buy the prints from me. So, but she's not that way.
But she's not that way. That's nice.
Yeah.
Okay, so copyrights. You get automatic protection in copyrights. You don't have to register anything, but you can register. So the minute
what's the benefit of registering?
The benefit of registering is that you can get what's called statutory damages. So you get a set amount of money for every infringement of your copyright. And it's usually more than your actual damage. You don't even have to have like actual damages, meaning any loss of money or revenue.
Yeah. It's just the people are making money off of your stuff.
So you can get a certain amount for each.
You're getting a loss because you lost the opportunity to make that sell because they took it.
That's right. Yeah.
Hey, look at it. See, I should have been an IP lawyer.
Yeah. Oh, there's one more copyright in that video that I forgot to talk about. That's my copyright.
Oh, because you made that video.
Yep. And then there's Wisecast copyright because Wisecast is producing this video that includes that video.
So we're getting this big old web of copyright.
Yeah.
Look how excited you're getting about this. It's layers like an onion, dude. It's just layered and layered. You never knew that IP law was so interesting.
That's right. Yeah.
It is cool, though.
It is cool.
No, because...
But you have to think about that as a podcast producer and as a video producer and social media producer, because everything you do is going to have layers and layers and layers of copyright. Right. And that's all got to be clear.
Yeah. No, and I've already kind of foreseen some scenarios where that might be an issue.
So you're going to have a soundtrack?
For my what?
For your videos?
Yeah.
Well, are you going to write the music?
No, I'm lucky because I'm going to get I'm going to get permission from the person that has the copyright to be able to use his songs free of charge.
Oh, that's nice.
Until we start making money, and then, obviously throw him a bone.
Okay. Well, that's nice.
What do you mean?
All right.
A little bit.
So we understand copyrights now.
These tangible I do.
Things. It's awesome.
Yeah.
So we keep talking about brands too. Brands keep coming up.
Yeah. So those are trademarks?
Trademarks.
Or service marks?
Yeah. Well, there's a difference. A trademark is a brand associated with a product, a tangible product.
Yeah.
A good that's offered for sale.
Okay. So like Nike.
Nike sells shoes. Yeah. The brand, the swoosh on the side of the shoe, that's a trademark because it's associated with goods for sale and commerce.
Yeah. And but you can't trademark, like Apple could use Apple as a trademark because it wasn't dealing with apples. But if it was like an apple farm or an apple juice, they couldn't trademark the apple, right?
Oh yeah. So what you're getting to is the type of trademark. So there are like 4 main types: fanciful marks, arbitrary marks, suggestive marks, and descriptive marks.
Okay.
And fanciful and arbitrary marks are easily protected. Suggestive marks and descriptive marks are not.
Okay. That's even...
Okay, so let me give you a trademark example.
Okay.
So you know what Supreme is?
Yeah, they do. The only reason why I know is because we have a neighbor that wears one. And it's a cool sweater. It's got like Jesus on it.
Yeah.
Yeah. Okay, Supreme.
Okay, so Supreme, what they do is they take this little logo, the red box that says Supreme, and they just stick that Supreme on stuff. And a lot of times it's like Hanes t-shirts or other stuff. It may not be their own sourced products, or it may be their products specifically. But what it does is it just applies their brand to whatever product as a designation of origin. Okay. Service marks are different than trademarks because they're associated not with goods offered for sale, but with services offered for sale. So Wisecast is going to have 2 different types of brands.
They're going to have a TM and an SM?
Yeah, because the videos could be classified as goods.
Yeah.
And they're producing those videos. But then the podcast production services that you're offering to your client are services.
Is it good to have both? It's just more protection.
It doesn't matter. It just depends on what you're doing.
We need to protect ourselves.
Are you offering goods or are you offering services?
Yeah.
Does that make sense?
Yeah. And we're offering both.
Yeah. So we would then
So would
register
you
both a service mark and a trademark.
On Wisecast?
Mm-hmm.
Okay.
And it would be under, you can register under multiple classes if it's applicable. And so there's a separate class for services. Okay, so trademarks and service marks can be logos. They can be word marks. They can be sounds.
What do you mean by word marks?
So like Wisecast, that word is a word mark.
Okay. A word what?
Word mark.
A word mark. Okay.
It's a mark that's just a word.
Oh, okay. It's like a trademark, but a word mark.
Well, it's a trademark and a service mark, but it's just a word.
Okay.
Okay. It can be a logo. And so in your case, you have that.
Is that
Wisecast.
a logo mark?
Just,
that was funny.
it's not funny, man. You're throwing my game off here.
Am I?
No.
I'm sorry.
fine.
I'm just, I mean,
come on, man. All right. So be serious with me for a
I
minute.
am being serious. I'm actually learning a lot.
So the logo that Wisecast has
Yeah.
is the Wisecast lowercase in that particular font with the like light bulb thing over it.
Can you trademark?
We could do those separately.
Yeah, but can you trademark? Because I don't own that font. Do I have to create my own font to be able
No.
to?
It's just that word written in that font.
So if I choose this font,
Mm-hmm.
so that's probably. So that's an interesting thing. You could probably do a whole thing on just fonts.
Yeah, all it is it doesn't matter what font it is. It's just that you've uploaded an image of it.
Okay.
And it's recognizable in that font.
But what if someone does a font and they don't sell it to Adobe or Microsoft or Apple? They have their own font.
We've just spun out of control here. So that font, that's covered by copyright. It's totally different. What I'm saying is your word mark, Wisecast,
Yeah.
written in the specific font that it's written in as an image is a logo.
Yes, I get that.
Okay.
Yeah, I get that. I'm just saying. I just had another question about people that are creating fonts.
So people who create fonts are creating
That's a copyright.
A copyright.
Okay.
Because it's a unique look of text.
But they could also. Okay, you're right.
Right? The font is a creative work.
Yeah.
Okay.
Yeah.
Like calligraphy.
Do people steal fonts from other people?
Yeah, man. Fonts, you have to pay money sometimes for fonts. Sometimes like $40 for a font.
Really?
Mm-hmm.
I'm gonna get into the font business.
I know. Are you a calligrapher?
No.
All right. So here's an example of a service mark. You know who Paris Hilton is?
Oh yeah, her dad owns Hilton.
Yeah, that's right. Her dad owns Hilton.
Yeah,
Hilton
I know who she
Hotels,
is.
right?
Yeah.
So do you remember? I mean, it was when we were younger, but do you remember she was on TV a bunch?
Yeah, with her friend Lionel Richie. No, was it Lionel Richie's daughter?
Yeah, Nicole Richie. How do you remember that? That's amazing.
Because it was a funny show.
What
I thought that was funny.
What did Paris always say to Nicole Richie? Again, high school.
Beep. Beep.
No, she'd always say.
I don't know. I don't remember it that well.
She'd
Like,
always
this is
say-
funny. You're like, how do you remember it? And then you're going to tell me what she says.
Yeah, she said, "That's hot."
Oh, yeah, that's right.
Do you remember that?
Yeah.
Oh, that's hot.
That's hot.
Yeah.
Yeah.
She'd say that all the time, right?
Yeah.
Turns out she registered that as a service mark.
Really?
Mm-hmm.
So what does that mean? Like, I can't say it in the movie?
Well, so what happened was Hallmark made a card that had a likeness of Paris Hilton and the phrase "That's hot" on it. And she sued him and won for infringement of her service mark. That's hot.
That's crazy.
There you go. All right, so we're talking about trademark and service mark protection. So
Sure.
they need to be registered. They don't have to be registered, but they ought to be registered with the Federal Trademark Office. And if you don't register them, you can still get state-by-state rights, but it's a little harder to prove infringement and ownership and all those sorts of things. You can also register trademarks internationally through what's called the Madrid Protocol, but I don't think you care about that. But that's handled by the World Trade Organization. Okay. So that's what we have covered with videos.
Okay.
Okay. Then we also talked about the cup.
Yeah.
Right. It turns out that there are different types of patents. There are 3 different types of patents. There are utility patents, so that covers the usefulness or use of a certain inventive article.
Okay.
There's a design patent. So you have this cup. This cup has a use. It's for holding water, right? But it has a special shape. It's curved bottom and, a certain proportion.
It does kind of amplify the water in a different way. Yeah. I never even noticed. Now all I'm going to be doing is looking at the shapes of cup and how it aesthetically...
So the shape, the way that it amplifies the water, that is its use. That would be covered by a utility patent.
Okay.
The shape or look of it would be covered by a design patent. They're totally different things.
Okay.
And then you have a third type of patent, which doesn't really apply here, but it could apply to other people, which is plant patents. So you can patent certain types of plants.
Like the Carolina Reaper?
Yeah, like hybrids, right. So here's an example of a utility patent.
Okay.
Can you tell what that is? No. It's a banana suitcase.
Oh, my next guess was it was going to be a chromosome.
Nope.
A banana?
A banana protective device is the title of this patent.
So you put your banana in there?
So it's a banana suitcase.
Okay.
All right.
So
this is actually it's got a use, right? You stick a banana in there, you close it up, and then it keeps your banana from getting bruised while you're carrying it around at your lunch all day.
Do you think this ever happens? Sorry, but do you think this ever happens? You think there's someone at the patent office that's like, they get this patent that comes in and they're like, dude, you guys got to see this. It's a banana backpack. And they're like, no, it's not. And then like 2 days later, someone else, so random, no one else has done it. Like someone else does the exact same thing. Think that ever happens?
I think it happens a lot.
Well, with certain things, but not like this.
Yeah, that's true. Not necessarily banana suitcases.
Because I'm sure they have like, oh, we got another one of these. Yeah. Got another fidget spinner.
Yeah, that's right. Well, actually, they have certain art units is what it's called. And they have certain examiners that handle only certain types of technologies.
That would be a fun job.
Would it?
If it was for toys.
Maybe.
Like you got
if you were the toys. Banana suitcase.
Or you got the weird.
Yeah, right. If you're the banana suitcase examiner.
Yeah, the weird stuff.
That might be fun. Okay, so this is a useful article.
Yeah.
And because of that, you get a utility patent for it. Okay, so here's the design patent example.
Raggedy Ann?
Raggedy Ann.
Is that the original ones?
Yeah, that's the original Raggedy Ann design patent.
They look evil in this one.
Super creepy, right?
They look like...
Can you imagine giving that to your kid?
No, it's terrible.
Yeah.
What are people thinking?
Creepy. So
we definitely have to put these pictures up.
Yeah. Fun, right?
It's creepy.
Yeah.
That's bizarre. They look... Okay, so yeah, we're keeping this short. My bad. All right.
Yeah. So, creepy Raggedy Ann. Yeah, that's the original design patent for the Raggedy Ann doll. And what we're looking at is just the design of it. You can tell that we're looking at just the design because there are no lines with numbers.
Okay.
In a utility patent, there are lines pointing to pieces and they're numbered. And in a
showing
design patent,
the utility of it.
Right.
This is okay. I got you.
In a design patent, there's none of that. It's just the look of it.
Maybe we should find an example of that.
Yep.
Okay.
So here is an example of a plant patent.
Okay.
I think that's called Angel's Trumpet or Devil's Trumpet. One of the two. Jimson weed is what it's called. And this is a hybrid variety of that someone has produced. And because they created that hybrid, they were able to get a plant patent for it. So there are the examples of the 3 different types of patents: plants, designs, and utility. Okay, there you go.
Thank you.
Mm-hmm. So you obtain a patent by filing an application with the United States Patent and Trademark Office. And if it's a utility patent, it has to describe all the functions that are important and have a set of claims. If it's a design patent,
you have to like show
pictures
and
pictures.
Stuff.
You don't have to. You can.
Stuff.
You don't have to, but you can and probably.
What if
should.
you don't?
It's not a big deal if you don't, but really it's kind of helpful to describe the invention.
But it doesn't have to be the final product.
Right. But a design patent must have the pictures. That's the whole right, is the pictures.
Yeah.
And same with the plant patent. You need to have the pictures in the plant patent to show what what the characteristics are of the plant, so it's identifiable.
Okay.
Okay. All right. So each country issues its own patents, and they're jurisdiction by jurisdiction. So if I have a Canadian patent, I can't enforce it in the United States.
So I could go here, find a product I like, go to a country where they didn't patent it, reproduce it, do the patent there, and there would be no conflict.
Technically, no, you can't do that because
But you could.
patenting in one country is usually a bar to patenting in another country.
What do you mean?
Means if you patented it in the United States, then you typically can't. If you're not the original author and you didn't file the right protocols, you typically can't file a patent on someone else's invention in another country.
Okay.
Now, practically speaking, it happens, like in China, for example. It happens. But
it's like the
not
Wild
to
East.
happen. Right. Yeah.
Instead of the Wild West.
Yep. You can file international patent applications, but there is no world or international patent. You have to file this international patent application, and then it has to be nationalized in each country that you select. So you could file what's called a PCT application, and then you would select the United States, Europe, Canada, China.
Can you do Europe like the
European Union? Yep. But then once you've got a grant in the European Union, you have to validate it in each country individually. So, and it's really expensive.
Is it worth doing it?
For some people, it's worth it, but
Depends on what it is.
yeah, depends on what their market is and everything.
Ah.
So,
Okay.
yep. So there's a bit to protection of that. Okay, so that's pretty much it on patents. Now, the last kind of type of intellectual property that we're going to talk about is trade secrets and proprietary information. So trade secrets are...
Let me guess.
Yeah, you guess. Tell me what trade secrets are.
Trade secrets are if I hire a bunch of people to come work for me, for my production company, and I teach them my techniques, I teach them my let's say I'm teaching them how to do a podcast, I teach them questioning, I teach them all sorts of curriculum that I develop, all this training material.
Mm-hmm.
And then this person leaves me and goes to another place and takes everything that I taught them and goes and implements it and teaches it to them.
Mm-hmm.
Would that be a trade secret?
Well, it depends. It depends on if you've taken the steps necessary to make it a trade secret.
So you got to make a trade secret.
Yeah, so you have to have...
So if I
have
do
agreements in place.
Yeah.
An employment agreement.
Like an NDA too.
Mm-hmm. Employment agreement that includes a confidentiality provision or terms in your employee handbook that provide for confidentiality and protection of trade secrets.
Because people are doing that, right? They go out and sell this stuff, sell this information.
Yeah, for sure.
They've made movies
They have.
about this.
They have, yep.
I can't think of the name of one, but I remember watching one. I liked it.
Yeah. So you have to cover that all by contract.
Ant-Man.
Ant-Man? That,
Remember?
yeah. Trade secret misappropriation is in that one.
Heck yeah.
Mm-hmm.
I'm going to go watch that movie with a different perspective, a different lens.
Nice.
You've opened my eyes. Like a couple things. I'm never going to look at glasses the same now. Like I'm going to always look at to see the design of them, which is ridiculous because something this simple you don't think about.
Uh-huh.
Speaking of, we could do a whole podcast on IKEA.
Yeah. Well, half of what Brooke does is design patents for cups.
So she's a cup connoisseur?
Oh, she knows all about the cups. All those metal tumbler cups.
She knows every...
She's done the design patents for all of them.
Yeah.
Mm-hmm.
That's awesome.
Yeah.
Okay, so that's trade secret. So you want to, if you have that, you need to protect yourself. And then what's proprietary?
So proprietary information.
Help me say that.
Proprietary.
Proprietary.
Yeah, proprietary information.
But if you say it quick, it's proprietary.
Yeah, don't say it quick.
Proprietary. Proprietary.
Yeah, did it.
Proprietary.
Yeah, so that's like this. If I were to prepare this presentation and I wanted it to be an internal document only, I would mark it proprietary information. And that
Kind of
way,
like classified?
Yeah, kind of like classified. It means it's for company eyes only.
Yeah.
Not for any external.
You get that
use.
with a lot of emails, right?
That's
At the bottom.
confidentiality. Yeah.
But so that's different.
Yeah. Maybe. I mean, typically if you're...
Proprietary, is that more of you're giving them stuff that pertains to
If it's an intra-office email, then it might include a proprietary information clause in there.
Yeah, because this is information that
is meant to be within the company only.
And maybe you don't even fully understand everything. Okay, I got you.
Yeah. So a lot of times you'll see on the bottom of the emails, confidential and proprietary, and it'll say, if you've received this by error, please delete all copies and notify the sender. Yeah. Right? So that's protection of
do people ever do that?
Proprietary information.
I bet people do.
I bet people do. Yeah, I've done it before.
Yeah, if someone sent me something they shouldn't be sending, I'm going to start looking at that more closely.
Yeah, I've definitely done that in the past.
Yeah.
So
okay, so you want to...
Here's another thing, lab notebooks. Some engineering companies will ask you to have a lab notebook, and what that is a way of collecting and documenting all of their proprietary information. So everything that you do, the contact list that you make, the notes about your projects that you make, notes from your meetings, all that stuff, they're collecting all of that proprietary information and having documentation of the fact that it is proprietary in that lab notebook.
Yeah.
So if you're an employer and you want to make sure that you protect your proprietary information, having a lab notebook policy is a good idea.
Yeah.
But there's really no other reason.
You never really need to open up that book unless something happens, right?
Well, I mean, it depends if what your policy is in your company. Yeah, so if you're an engineer and your company has a policy about it, you're going to be required to maintain a lab notebook.
Yeah.
And then you usually can't keep those lab notebooks. You have to turn them in.
That's what I'm saying. I was thinking of more of someone that was taking pictures. Like on your phone, you can take pictures of all your notes, and
Mm-hmm.
Can companies make a policy that says you can't take your phone into the place because of we're afraid of pictures?
Yeah, for sure. And that gets even more interesting when you're talking about engineering companies that have secret or top secret government programs.
Yeah.
So usually those facilities will have locked, or they're called black rooms.
Yeah.
And those black rooms typically don't allow cell phones.
Yeah, because they want to protect themselves against lawsuits and this stuff.
Right. Yeah. Yeah.
Yeah. So it's not just good to know these laws to protect yourself on what you own, but also so you're not screwing yourself by stealing someone else's idea and doing something illegally.
Yeah, that's right. So for you, especially where you're going to be working with copyrights all over the place and other people's brands and all those sorts of things, you want to be really clear on how you're using copyrights and trademarks in your videos.
No, it's great. It's great to have someone that knows that to help out, right? Because if not, you can screw yourself.
Yeah. So there are some ways that we can transfer intellectual property rights. You can have assignment, which means just a direct transfer of ownership. You can have a licensing, which means I still own my IP rights, but I give you a license to use them.
Yeah.
Every time you click on a click-through license in software, when you install new software, you're agreeing to a license agreement.
Yeah. Well, it's like companies that they own the logo, but they'll let other companies go and print it all off. Mm-hmm. So it's licensed by the NCAA, and they're not producing or doing anything. They're just getting a cut.
Yeah.
They're letting you use their logos.
Yeah.
Oh, yeah.
You can have technology transfer or manufacturing agreements. So let's say I'm a U.S. engineering company and I want to have a China company do manufacturing for me.
Yeah.
I would have a technology transfer agreement with them where I license to them rights to use for the sole purpose of manufacturing my products for me.
Okay. So I got licensing. That makes sense.
Joint development agreements. If you and I work together on a project and I do certain things and you do certain things, then the joint development agreement would help us understand who owns what rights.
Could you make it a thing that you both own the rights or no?
Yeah, you can do whatever you want in a contract. Employment agreements for things like trademarks.
That's to protect people that were always doing the projects in school. Mm-hmm. There's a group of 6 of them, and they always did the work. They're like, forget that. What I work on is mine. If you guys don't help out, I own it. And I get that.
Yeah.
I get that.
Yeah. So employment agreements are for things like trade secret and
by the way,
contractor
I was
agreements
never that kid.
For confidentiality.
All right, sorry.
Yeah. You were that kid.
I never was that kid. Yes, all right, go ahead. So what was the last thing you said?
Contractor agreements for confidentiality. Okay. So employment and contractor agreements are basically to maintain trade secrets. Okay. All right. So you can enforce intellectual property rights by having a lawyer send what's called a cease and desist letter.
I've heard of those. Hold on.
So we can enforce intellectual property rights by a variety of means. So yeah, that's right. Cease and desist letters. You can have your attorney write a cease and desist letter to someone saying, "Hey, stop infringing these intellectual property rights."
They usually scare people off.
Sometimes it does, not always.
Elise had that. But Elise had to have that. Some guy was taking all of her photographs, marketing himself with her pictures.
Seriously?
Yes. And she's like, "You got to stop." He's like, "Okay."
Yeah. So sometimes it works, but not always.
When she sent the letter from the attorney, then it worked.
Yeah. So you can also do state court litigation of certain contract and common law rights.
Yeah.
Federal court litigation of federally registered rights. So patents, trademarks, and registered copyrights. Those can be in federal court. You can do arbitration in an international arbitration panel for cross-border contracts. Okay. So I said there was that manufacturing contract, right? The technology transfer contract.
Yeah. Between
a U.S. company and a China company. Which court has jurisdiction in that contract? It's hard to say. So you would go to international arbitration of that.
Okay.
Okay. And then also the International Trade Commission.
Have you ever worked on any of those cases?
Yeah.
Are they fun and exciting?
They're interesting. I don't know if I would say fun or exciting, but they're interesting.
Okay.
Yeah.
I bet if you were working on the banana.
If I was working on the banana, I'd be super excited about it.
The banana backpack?
It'd be just like fun all day long.
Yeah.
Yeah.
Yeah, for sure.
So the International Trade Commission will enforce importations. So if you have a patent in the United States and a foreign company is importing an infringing product, you can file an ITC suit and the ITC will stop at customs those products. Okay, there are certain defenses to infringement. So for copyrights, there's fair use and also parody.
Okay, I know parody and fair use.
Yeah, parody means I'm making fun of it.
Yeah, making fun of it. And then
fair
use is like education.
Yeah.
And
or strictly for comparative purposes, right?
Yeah. Mm-hmm. Yeah. Like I used to, teachers were really paranoid about stuff. And I'm like, why can't, the great thing about the internet and kids with cell phones and now schools having one-to-one is you don't have to print any of that stuff out.
Yeah.
Just go to your phone and go to the website.
And it's kind of all good because it's all for educational purposes, which is
But you don't even have to do anything now. Mm-hmm. Like even some of the learning management systems that are out there, what it does is it allows you to go to YouTube and embed a YouTube video. So you're not liable for any of that. You're just going up from YouTube. YouTube takes it. It's YouTube's thing.
Yeah. That's
and
nice.
They're making it easier for teachers to, embed. Embedding is great because it's like, it's not my code. It's nothing. I'm just let you see it from the original source on my page.
Yeah. Cool. All right. So there's also certain things like it's not for a commercial purpose. So if I use someone's trademark, but I don't use it for a commercial purpose, I make no money off of using that trademark at all. Yeah. Well, then it's not really an infringement.
But you're starting to see that on YouTube, right? Kids put stuff out there, then all of a sudden they're getting popular, and then they have to put these videos down.
Well, they're getting popular, and then there's ads, and then it's for a commercial purpose.
Yeah, right.
There's also an idea of trademark dilution. So if you start using someone else's trademark on it, like unauthorized use, can be considered dilution of the mark, and so they can sometimes stop you for that. Cool. The last thing is intervening rights, meaning you registered or you used a trademark in California, and I used that same trademark in Utah, and then you registered in the federal registry, but I had intervening rights because I used mine between the time that you used it in California and registered it federally.
Yeah.
Does that make sense?
So what do they do in those situations?
So in those situations, there's no infringement.
So they can keep going with it?
Yeah. Intervening rights is a defense. It's infringement.
That's cool.
Mm-hmm. Okay. So there are a few different kinds of careers that you can have in intellectual property.
A lawyer.
So you can be a patent lawyer, or you can be a copyright lawyer, trademark lawyer.
You could be a drafter or
an illustrator.
Illustrator.
Yeah.
I'm learning how to use AutoCAD and Inventor.
Yeah. You can be a patent agent, which is not an attorney, but they can still help you file patent applications. Okay. You have to be an engineer to do that.
Okay.
You can be a paralegal or legal administrative assistant. You can be a licensing manager. So that's a business person that's involved in handling transfer of intellectual property assets.
You could work for the government in their patent.
Right, yeah.
Did you have
Patent
that on
examiner,
there?
trademark
Did you have it on
examiner. No, it's not on there.
Boom!
Boom. Well done.
Thank you, sir. I've been trained well, taught by the best. So what else? Sorry.
So just a few takeaways from this conversation are be aware of what...
Wait. Let me do the takeaways.
Oh, yeah, you do the takeaways. I love it.
Yeah.
Do it.
All right. CYA. CYA. Like, if you have something that's valuable,
protect it.
Protect it. If it's something tangible, you're going to protect it.
Mm-hmm.
But also, you also have ideas and thoughts and cool things, processes and designs and whatever. You want to protect that. Engineering students, they're especially... the reason why they like engineering is they like to be thinking about things and
coming up with great ideas.
And so when they come up with great ideas, even now, like I've heard of so many kids people that have actually designed whatever the product is that made them millions and billions of dollars in high school because they didn't have anything else to worry about.
Mm.
So yeah, that's my takeaway is figure out, first of all, understand the different types of things that are going to protect you. This is all about protection.
Yeah.
As IP law is about protecting your intellectual property.
Mm-hmm.
So what I would say is be careful with what you're doing. Also, if you're working for someone, be careful, know what you're doing, know the rules.
Mm-hmm.
And anyway, those are the takeaways I got.
Yeah. The last final takeaway is know your dates.
Like the women?
Yeah.
Like know your girlfriends that you're
know your
dating?
girlfriends. No key dates. So there are certain events or activities for patents especially that limit your rights. So if you publish something or you talk about it in public or you offer it for sale to someone or you use it in public, it limits your international rights the day that you do one of those actions. And in the US, you have a 1-year grace period. But if you don't file your applications before those activities happen, then you may not be able to get coverage for your ideas.
Okay, that's a good one.
So know your dates.
Yeah.
Also, trademark dates include your date of first intended use and your date of first actual commercial use. You need to know those dates.
Well, I'm sure that people are going to have a lot more questions for you.
Thanks, man.
Thank you.
I appreciate you coming.